We will go on the record in the matters 24 CM 120, 25 CF 04, State of Wisconsin versus Luttrell Paffel. The state appears through District Attorney Kevin Schmidt in person. Mr. Paffel appears in person with counsel Eugene Harrington. We're set today in these matters for the sentencing portions of the case. The court ordered a pre-sentence investigation report. The court has reviewed this report. But without knowing all of the intricate facts and details, I was unable to determine if there were any material facts or information that needs to be updated on the record. Mr. Schmidt, did you receive a copy of that PSI?
I did. I reviewed it. I have no corrections.
Mr. Harrington?
I did receive it. I reviewed it. The PSI reflects that it's 25 CF 0411, count 11 is aggravated battery. Actually, that's an attempt, and the maximum penalties are outlined in the plea questionnaire. I don't think it matters so much, but I did note that. And then if you can give me just 1 second, there was something else that I saw there was a need to change. The recommendation from the department may be incorrect because it's an attempt and the maximum penalties. The recommendation may exceed the maximum penalty.
Well, I'm just looking at the charge that he pled to that's in our system, and it says aggravated battery, class H felony with the use of dangerous weapon modifier.
But it was an attempted aggravated.
But then that's not how it's calculated here. That's not what the system says.
Okay, but I think
So
the plea
then-
questionnaire and the plea were all to attempted aggravated battery as to count 11.
Well, then we need to redo this because again, our system doesn't identify it as an attempt. But in the notes, the minutes from the clerk do indicate attempt to cause great bodily harm, but
It is
perhaps-
attempt. It's in the plea questionnaire.
Yes, I see that, but that's not what I'm concerned about. We have that in our minutes too, but our system is identifying it as the full-fledged crime. I'm pulling up the order for PSI. I don't think it was amended on the PSI order.
Judge, in all honesty, I think it's one of those glitches that can be solved quickly. Second observation I have is that the PSI reflects that page 9, it says that the defendant was convicted of burglary in Polk County 19 CF 271, but the recitation from page 6 does not reflect a conviction for burglary. I didn't get a chance to look that up. Again, I don't think it makes a significant difference in the recommendation or the process today. But those are 2 items that I thought I should note to the court.
Well, the recommendation, it would be significant because Department of Corrections would need to be able to amend their recommendation based upon an attempt, not as a full-fledged aggravated battery with the modifier.
And only the upper end, only the upper range of their recommendation is above the max. The maximum is 3.5 in, 3.5 out. I don't think so.
What is the
'cause-
whole statute for the attempt? Or is
No,
there
1.5
an
out.
added attempt statute that needs to be added because the system continues to pull it as aggravated battery with the use of a dangerous weapon modifier?
The attempt statute is 939.32 sub 1G, B, 2A, and B. It's, the maximum penalties is the attachment to the plea questionnaire is where I'm reading from. I know I put that in there.
Yes.
Did your attorney thoroughly go over that document with you? Yes. Did he essentially go over it word for word? Yes. And you understand everything completely?
Okay.
The penalty enhancer is 939-63-1C.
1C, not 1B.
Penalty enhancer is 1C. The attempt is 939-32 point sub 1G, sub B, sub 2, sub A and B. It's a long convoluted.
One on the plea questionnaire is 931.
So basically, the maximum offense by default is 3 and 3 out. Because of the dangerous weapon modifier, it becomes 7 and 3 out. But because of the attempt, you have both of those, so 3.5 and 1.5 out.
Okay, I understand that. I do need to send this, it needs to be sent back to DOC to get their recommendation, because that was the agreement. The state is, I believe, state was capped at
The PSI.
the PSI, so I need to have the PSI correct.
You're in charge, Judge.
I mean, can I go forward and move forward? Yes. And it's an imposed and stayed recommendation. However, the agreement is clear. It's the state capped at PSI. And Mr. Paffel deserves to have everything done correctly. And we have to pull, our system is incorrect anyway. We have to pull in the attempt portion to add that into CCAP in that system. Because Mr. Harrington, if you can recall how lovely it is to work with that, and it's not easy. As much as we would like to think that Danielle, or excuse me, Olivia can go bloop, 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 and just punch it in, we cannot do that, so. All right, so I guess we have to reset this and just see what DOC would change, knowing the attempt. Let's try and get it in as quickly as we practically can. Can it be on an ADA week or no?
It really needs to be on my week. We've been scheduling all over the place. That's made my calendar really hard to follow.
I can do February 13th at 9:15.
I would prefer in the afternoon, but
I can't in the afternoon. If you want an afternoon, it's not going to be until February 24th.
matter to you? No. February 24th works.
February 24th at 1. The 2, just in case. Do we have anybody any victims who are going to be making a statement?
I don't think so.
I don't think so. Okay. All right, we will get this sent back to Department of Corrections so they can correct and amend their recommendation. And then we'll go from there. And also you said, with regards to the Polk County conviction, because I would like that to be pointed out to DOC as well.
Yes, the
Burglary.
the burglary on page, if I could just review my notes quick, so I can
You
tell
sure
the
may.
specific page. Page 6 reflects Polk County case 19 CF 271. Counts 1, 2, and 3, doesn't mention burglary. But I think on page
9 it does.
9, it mentions burglary. They're inconsistent.
Yeah, I can't find. You can't find the attempt statute?
Can we say it one more time?
Can you say the
slower?
attempt statute one more time and not what's written on the plea questionnaire unless that is accurate? Because 940.19 paren B is not coming up.
It's 939.32. Parent 1G, close parent. Parent B,
All right. Thank you. All right. Thank you. Adjourned. Bail continue. Bail continues. We will go on the record in the matter 25, CF87, 25, TR 500, 504, and 26, TR 53. State of Wisconsin.
up to, comma, A and B.
A and B.
If the court needs it written down, it's on the bottom of page 4 of document 38. It's on the attachment to the plea questionnaire.
Okay. All right, we'll get this fixed and then we will be back once we allow DOC an opportunity to amend.
All right, thank you, Judge.
All right, thank you. Adjourned.
Bail continue.
Bail continues. We will go on the record in the matter 25 CF 87, 25 TR 500, 504, and 26 TR 53. State of Wisconsin versus Brandon Daniels. The 26 matter, a not guilty plea will be entered on his behalf. As to the other matters, we're here for a status, but the parties have reached an agreement and you would just like a sentencing date.
Yes, Judge.
I could do February 13th at 9:15 or 11.
Neither of those are going to work. If you could do slightly earlier, 8:30, I could do it. I need to be in Polk County by 10.
I can't.
Okay.
What about 2:45 on February 10th?
No.
$2:45 on February 11th.
Yes, that would be fine.
All right, 2:45, February 11th. We'll see you then. You can come get your notice and your free leave.
Can I get the case number for that 2026 matter? Was that a ticket?
Yeah, it's 26 TR 53.
Thank you.
It's an operating with a restricted controlled substance first.
Mr. Daniels, I'll talk to you about that later.
Okay. All right. Kevin Sanders.
I received a voicemail from Mr. Sanders saying that he was not going to be able to make it in person.
I think, and Jacqueline Anderson
Both,
too.
yes.
My assistant gave them the Zoom.
Thank you.
So Sean Schaff. I do not have them on Zoom though.
We'll worry about that when the time comes.
We will go on the record in the matter 25 CF 64, 25 TR 291, 292, 293, State of Wisconsin versus Sean Schaff. The state appears through District Attorney Kevin Schmidt in person. Mr. Schaff appears in person with counsel Daniel Chapman. We're set for status conferences. Mr. Chapman, please update the court.
Your Honor, the matter is resolved. We are eventually going to be asking the court to enter a plea with a joint recommendation. Mr. Schaff needs to work out a timeline when he's going to be ready to begin serving a mandatory sentence. Part of that is going to be based on medical surgery schedulings, and he has a test tomorrow, and after that, he'll know more information. I'd ask for another status in about a month and a half, and hopefully we'll be able to give you a specific date that he'll be ready at that point.
Can you do February 24th at 2?
No, I'm in Hayward that afternoon.
February 27th at 10:30.
I'm in Polk County at 10. And, and then I'm back here at 11.
Here at 11.
Yes.
Let's just do 11. February 27th at 11.
Get what information you can. Get back to me before then. We'll talk, and she'll have a notice for you.
And off the record, but for the record, for your record and for your notice, I understand that this, if you're pleading and it's a mandatory minimum, I'm willing to give you some time. Because I
Yep.
understand.
I have
what you're
children and
doing.
stuff. Yeah, I need to figure
Yep,
out where they're
I
going.
understand all those things. I'm not in a rush because you are pleading. I'm willing
Following
to
your
give you
bond.
time.
Thank you.
So just to come back that quickly, I just want to get an idea of your medical stuff so we can know that stuff. But again, I would be willing to even give you a little bit more time. All right, Mr. Ullman. We will go on the record in the matter 25 CM 102, State of Wisconsin versus Carl Ullman. The state appears through District Attorney Kevin Schmidt in person. Mr. Ullman appears in person with counsel Daniel Chapman. We're set today in this matter for a plea and sentencing. Mr. Chapman, can you please recite the agreement for the record?
Your Honor, this offer was contingent upon Mr. Ullman getting an alcohol and drug assessment and doing whatever recommendations were required from that assessment. He has done his assessment and he's participating in outpatient treatment 10 hours a week at Fairview. I forget the name.
Fairview Recovery Services in Adena.
Thank you. Based on that, the state has agreed to a plea of guilty to disorderly conduct as a domestic with a joint recommendation for costs plus the $100 surcharge.
All right. And Mr. Ullman, that's the agreement that you've reached?
Yes.
Victims' rights compliance?
Yes, Your Honor.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney thoroughly go over that document with you?
Yes.
Did he essentially go over it word for word
Yes.
and you understand everything completely?
Yes.
Is that your signature on the second page?
Yes.
You're 61, you have 12 plus years of schooling, you can read, write, you understand the English language. Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt and the maximum penalties. Is that all correct?
Yes.
And there are no mental illnesses or disorders and no alcohol, drugs, or medication.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around June 28th, 2025, that in Burnett County, Wisconsin, you caused bodily harm to KST by an act done with intent to cause bodily harm to that person without that person's consent, and that it is a domestic type relationship? Do you understand what the state would have to prove?
I do understand now. What were the initials that you used?
KST.
I believe the correct initials are KMT.
KMT. All right. So with KMT, okay. There's a KST and a DMT that I have.
Yes, those were also present.
Okay. And so you understand the maximum possible penalty could be up to a $10,000 fine, 9 months of incarceration, or both, plus a $100 surcharge.
Yes.
And do you understand that I'm not bound to follow any agreement that's been reached? And the agreement here is for costs and fees only. Do you understand that?
Yes.
I could sentence you to the maximum penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? That original charging document that has facts that said basically this is what happened?
Yes, I did go over that with them.
And he's showing you a copy of that right now. For the most part, are those facts accurate? for the most part, are those accurate facts?
Yes,
Would it help if, do you need hearing assistance? They have.
I am
earphones.
hard of hearing, but I
You
can
can,
understand here.
okay.
Just making sure.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
No,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Oh, actually, I went over the battery with you and he's pleading disorderly
Disorderly.
conduct. And so scratch that, but with the disorderly conduct, the state's gonna have to prove that you in a private place engaged in violent, abusive, obscene, or unreasonably loud or otherwise disorderly conduct. Do you understand what the state would have to prove for that?
yes,
And do you understand the maximum possible penalty on that would be the $1,000 fine up to 90 days of incarceration plus the $100 surcharge? Do you understand that?
yes,
Now, you're admitting you're guilty of disorderly conduct with that domestic abuse surcharge and component to it. Is that correct?
yes,
Mr. Chapman, may the court use the probable cause section of the criminal complaint for the disorderly conduct?
Yes, Your Honor.
Has anyone made any threats or promises to you for you to plead guilty to the charge?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
he has,
Are you satisfied with his services?
yes,
Any questions for the court or your attorney before we proceed?
no, ma'am,
Then as to count 3, disorderly conduct with the domestic abuse attached, how do you wish to plead?
guilty,
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 3. Counts 1 and 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered. Mr. Schmidt, argument.
I think the plea to this for costs is appropriate because of the steps he's taking in dealing with his issues, as evidenced by the letter shown to me by defense counsel, and just what happened with the case. This is a case where Mr. Oman was at his home with his girlfriend and her family. He got into a disagreement with them at some point, told them to leave. He went to the bar. He came back. They were still there. I think this would be a good way of trying. He blew a gasket. He got very angry at them and that provoked this confrontation. I think things would have gone differently if either they weren't still there or if he had not been drinking there. So I think this disposition appreciates what happened there, as well as really the only issue I think he has is the drinking. Thank you.
All right, thank you. Mr. Chapman?
Was he disorderly? Yes. Could a jury have found this as being justifiably disorderly? Yes. This was his cabin. His girlfriend had her own place. He was fully justified in kicking people out of the house, and I don't think they were really in any position to tell him not to smoke in his cabin or camper. But did he handle it properly? No. He has no prior record. He's done an assessment. He's doing outpatient treatment, and I agree. This is a fully acceptable disposition. The public will be protected.
Thank you. Mr. Ullman, do you want to say anything today?
no, I believe everything's been said,
Okay. I think this agreement is appropriate. You've taken the steps that you need to address the issues that you have, your alcohol issues, as well as doing a domestic violence course. And you did so without being ordered to do that. And so you got the benefits of that for this offer, plus you get the benefits for your life. So I think that that's appropriate. So I don't think the public is at safe or is at risk. I think you've learned a lot, and so that this is a reasonable agreement. So I'll accept it. I will assess $600, $500 for costs and fees and surcharge, plus a $100 domestic abuse surcharge for a total of $600. You do have $2,000 posted, so the rest will be remitted back to you in a couple weeks, okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is ordering you to provide your DNA to the Burnett County Sheriff's Office. If they need it, they'll take it. If They don't need it, they'll send you on your way. You have the right to request it be expunged through the system through a written letter to the Department of Justice, okay? Not to
Okay.
the court, but to the Department of Justice. So what you're gonna need to do is you're gonna need to take a form here and go to the sheriff's department, provide your DNA, and then you should be good to go, okay?
Okay,
All right, Mr. Schmidt, is there anything else that the court's missing?
No.
Mr. Chapman?
Nothing else. Thank you.
All right, good luck, Mr. Ullman.
thank you.
Thank you.
One last question I have for you. Do you know what it means to appeal?
Yes.